About to start, and I'm looking forward to us having very, you know, discussions that do not limit us in terms of the course that we are discussing. Earlier on in the morning, we had the opportunity to hear presentations from our seniors. When you look at the program, you're going to realize that we were supposed to have panel discussions and FAQs. However, we have just gotten information, or we got information earlier, that DPP is having a sideline with the DPP of Ghana, together with Ms. Nyamosi. So what you're going to do is that since the discussions that arose from the morning discussions, we are not able to exhaust them. And the fact that it is us, together with the stakeholders who are here, that are going to, prosecute, are going to come across the cases that are going to come. Because when it comes to election offenses, we never anticipate the spontaneous acts and omissions that do happen. However, what is critical and what arose out of the morning discussion, we have decided that you're going to have 3 panelists from our seniors, eminent colleagues who have worked with us, who have also participated in the previous election cycles that have been there. And we know some of the acts that have been enacted have arisen out of the gaps that happened or that have been taking place in the previous election. So we are going to have our chair of the committee who really coordinated this process to have this compendium that we have and that we are discussing with the stakeholders who are here. There is Mr. Kemo. Kindly please come. These chairs need to be occupied, and we need to ingest and share our experiences. I'm going also to ask our senior colleague, Mr. Omwega, to come and join the chair together with Mr. Waroi. I know the morning session, we were not able to exhaust, and I know some of us, the colleagues, there are those who wanted to ask some questions that arose out of the morning discussions and the presentations that were made. I was just mentioning to Mr. Omwega that the idea that he came up with, or the proposal that he made, that we should think of strategies. We have laws, we have legislations that are in place, including the compendium that we have, and that we are about to go out there and sensitize our colleagues together with the stakeholders. And one of the things that I would also want to, just to kickstart the discussions, and why we also need to think of the strategies, is, I'm not going to mention which case it is, but it transpired actually last week. It's a case that involves a senator, and when the matter came up, whether deliberately or by intention, the said senator didn't have a defense counsel in court. When the court record was looked at, this is a matter that has been adjourned. Actually, it is a 2019 matter, and it's a matter that has not taken off. And with the previous directives that the CJ and President of the Supreme Court had given, which are very good, there were directives that cases that relate to hate speech and incitement, they should be fast-tracked. Because what is happening is that the public out there is basically getting lethargy. So what happened when the matter came up, the senator was asked, where is your counsel? The senator was, say the counsel said he's going to come, he's not here. So what the court did, the court explained to the accused person and informed him that the matter has never taken off because of his conduct. So the matter shall proceed. And immediately the senator started shouting in court, and brought havoc. Such havoc that, made the proceedings in court not to proceed. And we all know, and this is one of the discussions that I would want us to have, when we spoke with the Chief Magistrate and my colleagues who are prosecuting that matter, they invoked Article 50F, which stipulates that, you know, if the conduct of an accused person makes proceedings, you know, judicial proceedings not to proceed, and the particular accused person has been made aware of that such conduct would make the, you know, the administration of justice be difficult, then they can be, you know, dispensed with. So what happened is that the senator was removed from court and the door was closed. The proceedings continued. Barely 2-3 minutes, that door of the court was being knocked, almost, you know, falling down. So what the Chief Magistrate did, said, it's fine, let him come in, explained to him that, you know what, the reason as to why we had to dispense with your presence in court is because of your conduct. But if you're going to assure us that then you're going to cooperate, then we have no problem. So the magistrate, the accused, sit down. Barely the witness just proceeding, he started the same drama again. So in my mind, all of us who are seated here, we all know what the strategy was. The strategy was to ensure that this matter doesn't proceed. And you can see that is a strategy which we could say that it worked to some extent. Because what happened is that the proceedings of that day, because this matter had 2-3 days back to back, the matter had to be taken out, and the judicial officer said, you are proceeding the next day. So what happened the next day? Same. The counsel came and said, we are making an application for the magistrate to recuse herself. Oh God. So when you're having these deliberations, the action has already started. You know, even as we launched the COMPENDIUM yesterday, the action has already started. So now, there's a ruling that is pending for that. So that is a question that, as colleagues, I would want us to pose. And because we are here as stakeholders from the judiciary, from the NCIC, the police, we come up or we think of strategies moving forward. Because for sure, as our senior Mr. Moga was saying, as our landed chief magistrate, Madam Nyaloti was saying, is that this is where the rubber meets the road. So I think for me, that is what I would open that discourse. And that is one of the things that I would want our panelists, you know, out of their experience, you know, to respond to that. And then I'm glad that the discussions are already getting very Karibu-san. Where is the, Mr. Hassan, you said we should not lower. Where's the? It's good that we do this so that when they come to contact tracing, I don't want to be.
Thank you. I would like Mr. Akula to just come and share the experience we had. I was the trial magistrate in a matter of a politician in Mombasa, and the prosecution was very ready, always ready to proceed. We had gone through the pre-trial, and 5 times the matter had been adjourned.